Hello, and welcome to an episode that talks about defamation. I am Swati Singh, a media professional for the last 12 years specialized in mass communication. I have worked as a journalist with Hindustan Times, Indian Express, career launches, etc. And I have also taught in print and electronic media in various universities and colleges, including the Delhi University. So today we shall be discussing the law of defamation, which is a great catalyst in preserving the reputation of people, organizations, etc. The scope of this topic extends to how media and defamation are connected with each other. This episode gives an idea about how any of the information published by media can lead to defamation of a concerned person. It also includes the constitutional aspect related to media law and the responsibilities of media. Now, let us start by discussing the objectives of this episode. The objectives of this lesson are to understand the history of defamation, to understand the meaning of defamation, to learn about media and defamation, to discuss the legal aspects of law and defamation, to discuss journalism and defamation, and to understand the reasonable restrictions on media with respect to defamation. So, let's start with the history of defamation. The evolution of the concept of defamation came with a continuous conflict between the protection of character and the privacy of individuals, and on the other hand, the right to freedom of speech and expression. The seriousness of the issue was raised due to the enactment of the Human Rights Act 1998, which brought the right of freedom under the Article 10 of European Convention on Human Rights, ECHR. By the Times newspaper, that need to protect someone's reputation has been given greater importance under English law. Law of defamation basically gives protection from lowering someone's reputation to the public at large. But the main question is that to what extent the words spoken or written are considered as defamation. However, the claimant of defamation must prove the statement was defamatory and was published at large to degrade the reputation of the concerned person. The next step will be the relevance of the claim and the statement passed. It is very necessary that defamation is correlated with the effect of statement published at large, and the relevance should be there of the claimant and the statement. Therefore, looking at the certainty of the offence, proceedings to the relation of the media and defamation has to be approached in a very sensitive manner. The working of media is very responsible work, and it holds large bulk of information. Thus, there is a very thin line of difference between information and defamatory statement. And in this, the work of media has to be kept very precise. Defamation and media. With the daily development of various sources and technologies of communication which are now being developed, for instance, internet has been the favorite among all the present times. As say, social media has become a huge platform for communication worldwide. Looking at the Indian perspective, the communication to the public at large, media has played a vital role in this area. With the development in technologies, media has also been developed in each phase and has the capacity to influence millions of people every day with its content. In the modern time, it is very necessary that the public is made aware with the happenings of the country, especially in a very democratic country like ours. Here, media has to play a very vital role and very carefully, since it has large scale and large stake in communicating with the masses. As said, if the tree is nurtured in a proper way, then it will definitely give the proper fruit. The same way, if the media is used in a proper way, then it can be helpful at its extreme. Media is a wonderful platform of highest scope for communicating with people. But looking into the box of the Indian laws, some of the restricted lines are also down for the media. Laws of media basically speaks about the liberty and restrictions for the media of India. In a democratic country like India, there are certain fundamental rights for citizens, in which there is Article 19(1)(a), which is the right of speech and expression. This right is, however, subject to various sorts of restrictions, and Article 19(2), defamation being one of them. However, it is a universal principle that no right is absolute, and right to freedom of speech and expression is therefore no exception to it. Basically, defamation leads to the action of damaging the good reputation of someone. While under IPC, defamation is considered as an offence. If seen the other way in general terms, defamation is the publication of a false and derogatory or defamatory statement concerning another person without a just cause or excuse, whereby the person in question suffers injury to his reputation. Further, in relation to the media law, the question arises as to which production of news amounts to defamation and which holds the protection of freedom of speech and expression. Media plays a very vital role in reaching to people through the means of news and communicating to them or the public at large. It is the obligation of the media that whatever news they are printing or broadcasting includes fairness in approach and doesn't have a biased approach. Within the purview of the media law, one can't escape on a ground that he or she didn't know that what they were publishing, what not to publish. Whether it is print media or broadcast media, one has to keep in mind the publication doesn't lead to a defamatory statement. The position of a journalist leads to the same cup, as they can be charged of an offence while following their role. They hold the same as the other sectors. The owner, compositor or the word setter, editor, publisher and the author are all responsible for what they do, because they are the bodies accepting the bunch of matters to be published. Ignorance and mistake of the act can be used as defense over here. The liability of the editor or the chief editor subject to the case may be for the publication of any news material will depend upon the allegations and proof regarding the part played by him in the selection and publication of a news material. So the question is, what exactly is defamation then? Well, balance between one person's right to freedom of speech and another's right to protect their good name is defamation. Any intentional false communication, either written or spoken, that harms a person's reputation, decreases his respect, regard or confidence in which a person is held, or induces disparaging, hostile or disagreeable opinions or feelings against a person is known as defamation. Defamation is the act of making untrue statements about another which damages his or her reputation. Defamation may be defined also as a communication to some person other than the person defamed of the matter which tends to lower the plaintiff in the estimation of right-thinking person or to deter them from associating or dealing with that particular person. Defamation is a wrong done by a person to another reputation by words, written or spoken, sign or other visible representations. In the words of Dr. Winfield, defamation is the publication of a statement which tends to lower a person in the estimation of right-thinking members of the society, generally, or which tends to make them shun or avoid that person. Defamation is of two kinds, libel and slander. If the statement is made in writing and is published in some permanent and visible form, then the defamation is called libel. On the other hand, if the statement is made by some spoken words, then the defamation is called slander. Defamation may be civil charge or a criminal charge under section 499 and 500 of Indian Penal Code. The section 499 of Indian Penal Code states, whoever by words either spoken or intended to be read or by signs or by visible representations makes or publishes any imputation concerning any person intending to harm or knowing of having person to believe that such imputations will harm the reputation of such person is said to defame that particular person. Section 500 of Indian Penal Code states that Whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or both. To publish is to add to the intelligence of the reader, or to inform or make known to him something. To publish a defamatory statement or any matter or any news is to make it known to any other person that the one defamed, with that even a single communication will suffice. But it must have been done to a third person, because to communicate a matter is technically the object of defamation, which at the end amounts to defamatory statement. A defamatory matter may be communicated through means which reaches to the other party. What the victim must prove to establish that defamation happened. If the victim has to win a lawsuit relating to defamation, then the victim has to prove the various essentials, starting with the statement. There must be a statement which can be spoken, written, pictured, or even gestured. Next one is publication. For a statement to be published, a third party must have seen, heard, or read the defamatory statement. If there is no publication, there is no injury to reputation, and therefore no action will arise. Then injury. The above statement must have caused injury to the subject of the statement. It means that the statement must tend to injure the reputation of the person to whom it refers to. Also, we talk about falsity. The defamatory statement must be false. If the statement is not false, then the statement will not be considered as defamatory statement. Unprivileged. In order for a statement to be defamatory, it must be unprivileged. There are certain circumstances under which a person cannot sue someone for defamation. Let's explore the exceptions to this law. However, legislature gives room for the exceptions in the matters of defamation. Defamation holds the various defenses, starting with justification of truth. If the defendant proves that the defamatory statement is true, no action will lie for it, even if the statement is published maliciously. It is not necessary to prove that the statement is literally true. It is sufficient if it is true in substance. Another way is if the statement is fair and bona fide comment. A fair and bona fide comment on a matter of public interest is a defense in action for defamation. The essentials of a fair comment are that it is a comment or criticism and not a statement of fact, that the comment is on a matter of public interest, that the comment is fair and honest. Another criteria is privileged statement. Lawmakers have decided that one cannot sue for defamation in certain instances when a statement is considered privileged. Whether a statement is privileged or unprivileged is policy decision that rests on the shoulders of the lawmakers. If these are the cases, then the matter or the statement doesn't lead to defamation or a defamatory statement. Now let's come to journalism and defamation. It is very important that any of the published news is within the purview of the ethics of the media person or the journalist. One should see to it that the information communicated to the audiences leads to truthfulness and leads to the masses in a proper direction and doesn't create any negative impact in a society. The law endows every person with the right to maintain and preserve their reputation. The right of reputation is acknowledged as an inherent personal right of every human being. In other words, a person's reputation is his personal property and perhaps more valuable than any physical property, like land or ornaments. To justify this statement, one can cite a verse from the Bhagavad Gita that states that for a man of honor, a defamation is worse than death. It is considered as a great evil. Reputation is an important and integral part of dignity of individual, and the right to reputation is an inherent right guaranteed under Article 21, and it is also called a natural right. Defamation is injury to the reputation of a person. The essence of defamation lies in the fact that it is an injury to the esteem or regard in which one is held by the others. The legal system of India constitutes defamatory statement as an offence. Constitutional aspects. The constitutional aspects of the media law involve to certain fundamental freedoms. There is no direct freedom given in concern with the media law, but indirect freedom falls under the Article 19. This article gives the freedom of speech and, if seen in relation to media, Article 19(1) of IPC enumerates the freedom of speech and expression. This fundamental right plays a very vital role in relation to the freedom of media. The right given to media person also brings some of the restrictions to it. One can't use the right to its extreme. The other law has to be kept in mind with it at the time of implementation. Now let's come to the case laws. In Sakal Paper Limited, Union of India case, the Daily Newspaper Order 1960, which fixed a minimum price and number of pages which a newspaper is entitled to publish, was challenged as unconstitutional. The state justified the law as a reasonable restriction on a business activity of a citizen. The Supreme Court struck down the order, rejecting the state's argument. The court opinionated that it was a right of the freedom of the speech and expression which couldn't be taken away with the object of placing restrictions on the business activity of the citizens. It was thus inferred that the freedom of speech can be restricted only to the grounds mentioned in the clause 2 of Article 19. In another case of K. A. Abbas, Union of India, the petitioner for the first time challenged the validity of censorship as violative of his fundamental rights of speech and expression. The Supreme Court, however, observed that the pre-censorship of films under the Cinematography Act was justified under Article 19(2) on the grounds that film has to be treated separately from other forms of art and expression because motion picture was able to stir up emotions more deeply, and thus classification of films between two categories, A for adults and U for universal or all, was brought about. Now let's talk about the media responsibility. Media has always been a leader in communicating to the people, irrespective to any form of media. The news which is communicated by the media is a very great influential. Therefore, any news which leads to a doubt can create a chaos worldwide. Any form of media, before publishing it at public platform, should probably be analyzed and should not leave any doubt or conflict regarding its truthfulness. It is the moral duty of the media to serve the nation with a clear-cut surety of news. Media should show the picture of the actual problem to the citizens and let them decide by themselves of whether the successive step is connected or not, rather than starting the conclusive statement by themselves. It is not the duty of the media to give a conclusive statement of any sorts on an issue or make people dominated towards or biased towards a particular statement through their circulation or broadcast. Especially in a democratic nation like ours, in an environment where democracy prevails, the citizens are the main pillars of the nation and should be given freedom of their own speech and expression. Therefore, any wrong impact or any influential information in a negative or false manner creates great problem towards the future of our country or the nation at large. It should also be understood that before any of the statutory rights, it's a moral duty of the media to safeguard the power of media by accessing it within its ambit of jurisdiction and not creating an evil impact on the nation. Looking towards the statutory powers, there is no explicit right given to the freedom of media. While under Article 19(1)(a), the right to freedom of speech and expression, and under Article 21, the right to life and liberty is safeguarded. Further, looking at the other laws which restrict the powers of the freedom of speech and expression under the IPC Section 499, which states that the defamation compiled with sections 500, 501 and 502 of IPC, issuing to the punishment of the level of the offence committed. The statutory provisions are framed for the legal regulations to curb the regulating of fake information to the masses. The Information Technology Act also regulates the online platform of media by framing the regulations based on the offences that are committed online. It is very important that when people at large are dependent on a social platform and is also a great source of communication, that right information is actually released. The Information Technology Act also regulates the offence pertaining to any of the misuse of technology, which also gives a hand to the use of social media. Along with the other statutory laws, the IT Act should also be amended with the day-by-day upcoming misuse of media. Lastly, it is in the hands of media to disseminate information, and in what manner such information should reach the public should be well decided. The information should be open-ended and not a conclusive statement that leaves any of the impression on the minds of the users or makes them biased toward a particular statement or cause. Therefore, if self-regulation is done by media, the responsibilities are carried as it should be, then the question of legal regulations would not arise. If the situation is not within the ambit of the self-regulation, then the chapter of legal regulation has to be looked upon carefully for the justification. In other words, it is the moral as well as the legal responsibility of media to act as per the Code of Ethics of Media, its functioning and its role. Now let's come to the conclusion. From the discussion, we have understood that the media is a sector and is a very responsible sector connected with each and every field. Therefore, it is necessary that every aspect of media is looked upon carefully. With the interest in every field, it has to be seen that the information revealed by media is truthful and non-defamatory. It does not occur very often. Defamation and media are two paths of the same road. The usefulness of both in terms has to be done in such a way that they don't overlap each other, and as a result, defamation is not committed. It is very necessary that any information made at a mass level should be beyond the reasonable doubt, and as media performs that stage each and every time, the role of media becomes very, very crucial. In a democratic country like ours, journalism holds the maximum influence towards the citizens of its country. Therefore, if malafide information or the slightest of doubt arises from the information telecasted, then there should be an adverse impact which should be avoided. It has to be seen that the people forming their views based on information telecast are not influenced adversely by media. Though being a wide sector, it could be concluded that the defamation and media are two sides of the same coin. But the measures that should be taken is that they don't overlap each other and should perform within its self-imposed purview or limits. And now it's time for a quick recap. Today we discussed the meaning, significance of law of defamation. And we also learned about the various reasons to cite a defamation and various exceptions to the law. We also talked about the relationship between media and sensitive information and how media can violate some rules that pertain to defamation. Along with this, we also talked about various reasonable restrictions and laws imposed on media and the responsibility media should take while handling sensitive people's reputation, both online and offline. Well, this is all we have for you today. We hope you enjoyed the session. We shall soon meet you with another episode on media ethics. Till then, goodbye, take care and namaskar.